Welcome to DP Law Classes. As already we have discussed 29 problems that we have solved on law of contract, and now we'll go to the 30th problem, and that is A agrees to sell to B a specific cargo of goods supposed to be on its way from England to Bombay. It turns out that before the day of the bargain, the ship conveying the cargo had been cast away and the goods lost. Neither party aware of these facts is the agreement enforceable. So the very solution would be to this problem is based on section 20 of the Indian Contract Act and the very provisions of this problem is agreement void where both parties are under mistake as to matter of fact. So where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void, and the very explanation to it an erroneous opinion as to the value of the thing which forms the subject matter of the agreement is not to be deemed a mistake as to a matter of fact. So here both A and B were under the impression that the goods to be sold were in existence and on the way to Bombay. This was a mistake as the goods were already lost. This mistake was as to a matter of fact which the existence and it's on the way to Bombay. As a matter of fact, the goods were already lost. This mistake was as to a matter of fact which was absolutely essential to the agreement. The agreement is therefore void and is not enforceable. And now we'll go to the problem that is number 31, and the very problem is that A offers by a letter to sell his radio to B for Rs 200. B at the same time offers by a letter to buy S radio for Rs 200. The two letters cross each other in the post. Is there a contract between A and B? So this very problem is based on as the very answer to this problem. It would be no, as there is no contract between A and B. B is ignorant of A's offer to sell the radio for Rs 200. So also A is ignorant of B's offer to purchase the radio for Rs 200. Thus both A and B are ignorant of each other's offer at the time when each makes his own. There is no acceptance of each other's offer and hence no contract. As also we found the same problem in the leading case, Tin versus Hoffman and Company, and our next problem, that is problem number 32, where A sells and deliver goods to B. She afterwards agrees to pay for them in default of B. State with reasons whether the agreement is valid or void or voidable. So, here the very problem regarding the question of delivering good, the very answer is that the agreement is void for want of consideration. Ordinarily, any agreement without consideration is null and void and cannot be enforced in a court of law. However, according to Section 127 of the Contract Act, anything done or anyone promise made for the benefit of the principal debtor may be a sufficient consideration to the surety for giving the guarantee. However, in the given problem, no such consideration has passed, therefore, the agreement is void. And now we'll go to the very problem, that is the problem of 33. So, A owes B Rs 500 and C, a friend of A, offers a friend of A, offers Rs 1000 to B in satisfaction of B's claim on A, which B accepts. She accordingly pays to B Rs 1000 and B accepts them in satisfaction of his claim on A. Subsequently, however, B files a suit against A to recover the balance of the loan. So, advise A. So, this very problem is regarding the very section, that is the section 63 of Indian Contract Act, and the very section provides every promisee may dispense with or remit wholly or in part the performance of the promise made to him, or may extend time for such performance, or accept instead of it any satisfaction which he thinks fit. Here, the very promisee B accepts 1000 rupees in satisfaction of his claim on A. This payment of Rs 1000 by C is a discharge of the whole claim. B therefore will not succeed in the suit against A to recover the balance of the loan. So, the very next problem, That is problem number 35, where A borrows Rs 100 from B and gives him a bond for Rs 200 payable 5 by 5 yearly installments of Rs 40 each, with a stipulation that in default of any installment the whole shall become due. A made a default of the last installment. B files a suit against A for the recovery of the whole amount of Rs 200 can be succeed. So the very facts of this given problem are as per the provisions of section 74 of the Contract Act. Here the stipulation is by way of penalty, and when the stipulation is by way of penalty, the court only awards reasonable compensation in the event of A making default of the last installment. B is not entitled to the whole amount of Rs 200. It is left to the court to ascertain the actual loss and award the same, which amount is, however, not to exceed Rs 200. So, we have completed almost the 34 problems relating to the law of contract, and now we'll go to the 35th problem, and that is a consignment of 1000 bales of cotton to B, when who has made advances to him on each cotton and desires B to sell the cotton and to repay himself, but out of the price, the amount of his own advances, can A revoke this authority? So the very problem is similar to the provisions as provided under section 202 regarding agency coupled with interest. So the very section provides that the termination of agency where agent has an interest in subject matter. So where the agent has himself an interest in the property which forms the subject matter of the agency cannot, in the absence of an express contract, be terminated to the prejudice of such interest. Therefore, the authority cannot be terminated.